obviously a topic that is on the news and is timely for everybody. We're based in Richmond, Virginia. We're an employee benefits consulting firm, and Sarah is based in Texas. And we will get started here in just a second. I'm going to give everyone a minute to get on the call. One thing as you're preparing, due to the nature of the topic, it's changing a lot. This recording will probably not be sent back out just because there's a lot of things that are in flux still. So I encourage you to take some notes as you go through this. And also I encourage you to, as you're listening, there are going to be some Q&A at the end for you to ask questions. You can put those in the chat box. Sarah does a really great job of going through everything and giving everyone a highlight of what's going on. But certainly, if you have questions, put those in the chat box. And if we don't get to all those questions, we will be sending out some things afterwards. So I am recording all those chats and all those questions, and we may be doing a FAQ document with that going forward. So let's see, Sarah, it's 11:01. I think we're going to go ahead and get started. Thank you, everybody. Again, my name is John Millen. One of the managing partners for the Millen Group. We are based in Richmond, Virginia. We are an employee benefits healthcare consulting firm. We've been in business 20 years. We have clients in 13 different states, 130 different clients of all sizes. We specifically focus in a couple key areas: nonprofits, manufacturing, construction, blue-collar trades. Healthcare are some of the main entities, and the vaccine mandate has obviously been a big area on the news, and so I'm glad you can join us. I'm going to introduce you to Sarah Borders. Sarah is the principal of Benefits Compliance Solutions, and she's based in Texas. She is the go-to person for us when we have anything related to benefits compliance. She not only has the expertise and knowledge about the subject area, she's kind of probably like we are with healthcare. We geek out on this stuff. Sarah likes to learn and engage and is always on the front of what's going on. And she also has some real world experience. So she's not just an academic compliance expert. She's got real life, real employer experience for over a decade. And so with that, Sarah, I'm going to turn it over to you and take it from here, and I'll continue to enter people into the call.
Thank you so much, John. And thank you everyone for attending today's call. We're really excited to be with you today. I know this is a hot topic for everybody in kind of the HR employer world, as well as our world in employee benefits. And so we want to make sure that we give you the most up-to-date information regarding the OSHA ETS, how it impacts employers, kind of what's going on with the legal challenges, at least today. Today is November 12th. And so if you happen to be seeing a rebroadcast of this, this is what's happening today, Friday, November 12th. And so today we're going to look at, first of all, the OSHA Emergency Temporary Standard, or ETS for short. So you're going to hear me say that quite a bit if you're not familiar with that term already. And that's just simply emergency rulemaking that bypasses the normal rulemaking process where they have to get comments and then they issue proposed rules and final rules. And so this is what OSHA is doing to try to get people to be vaccinated and to end the pandemic. That's essentially why this was created in the first place. So we're going to look at sort of the overview of the rule and things that you need to know. I've included a lot of kind of frequently asked questions. And so I hope to address all of those before you even ask them. So if you don't mind, you feel free to ask questions, but once we get through the portion related to all of the kind of frequently asked questions, if I don't address it, please feel free to ask me the question. If we don't have the answer because either we just need to research it or we don't know yet because the rules don't speak to it, we'll try to get you an answer. But just type your questions into the chat. We have a lot of people on the call today, so just to preserve sound quality, we want to have everybody muted and type their questions into the chat. So I'll be monitoring that as we go through. So first of all, we're also going to look at the legal challenges on the ETS. We're going to also talk about vaccine incentives under the group health plan, because that's kind of what we deal with the most, is the group health plan itself And all of the rest of the stuff is kind of related more to employment law, but it does impact the benefits. So we're going to talk about offering an incentive related to health plan premiums, which is very common, and which is what was kind of sparked by Delta Airlines when they released that they were going to be charging employees who were not vaccinated an additional $200 per month for their health plan premiums. And so we're going to talk about things you need to think about if you're going to implement a surcharge or an incentive. So I just want to say that on the ETS, this rule is being challenged from literally every area, and many states such as Texas, now Alabama, Tennessee, South Carolina, Utah, there are a myriad of states, with many expected to follow suit, have issued either an executive order of some sort or passed actual state legislation, mostly creating additional exemptions from vaccination status as being a condition of employment. And so depending on what state your employees are in, or where you might have companies located, or where you're located, it can really impact how this rule is going to affect you, perhaps. So we also have many lawsuits pending right now, and I'm going to talk about specifically what's happening with that. So bottom line, things are changing rapidly and can be different based upon where you live and location of employees. So it's a really, really good idea. We strongly encourage you to engage with competent employment law counsel to at least review your policies and procedures, have a conversation. It is well worth the investment to run all of this by your employment law counsel if you haven't already. So this presentation, of course, is not meant to be legal advice. So please formulate a plan and get with your employment law attorney to review your policies and procedures. So OSHA issued its emergency temporary standard a week and a day ago. And so what it says essentially is that covered employers must either require employees to be fully vaccinated against COVID-19 or require that employees that are not fully vaccinated, they have to produce a verified negative test at least weekly and wear a face mask while at the workplace. And so covered employers who ignore this ETS, this is what it says, while it's in effect, could face OSHA citations and penalties of up to $13,653 per violation. And you could incur additional violations and penalties as determined by OSHA, whether it's federal or state OSHA, depending on sort of willful neglect, egregious failures to comply. In other words, they can assess more than the $13K. So this means that we don't exactly know how the per violation will be issued. Is it per work site? Is it per employee? Is it per facility? So we don't really know, but it could be all of the above. They certainly have the jurisdiction to assess penalties how they see fit, especially based on willful neglect and just outright defiance of this. And so that could be a really steep penalty if you start adding up numbers of employees, and if they find several violations, they could multiply 13,000 times, several violations. So in other words, we want to make sure that you take this seriously, and that if you are in a position to kind of take this on, if this is something you want to take the risk for, then you just know what the risks are. And so the timeline of the ETS is important too, because I want to make sure that employers understand kind of the timeline, because I see a lot of stuff about January 4th, and I want to be clear about the actual timeline of the ETS, at least right now. This could change based on the litigation that's happening right now, but for now, the timeline of the ETS is that employers must implement a vaccination policy. They must determine the vaccination status and get the proof, provide paid leave, and communicate the information regarding the ETS by December 6th. So Monday, December 6th. So this is the date that you really need to pay attention to, not necessarily January 4th. January 4th is when everybody needs to be vaccinated by, or weekly testing needs to actually begin. So you have to do a lot of prep work within the next few weeks, considering Thanksgiving as well. Again, assuming that the court challenges don't push or delay this, they could, but also the stay could be lifted, and then this just marches on as usual. So I would prepare right now as if there is no litigation, and just get your policies and procedures in place and determine how you're going to go about complying with this rule, if you are going to comply with this rule, because that's certainly an employer's prerogative if they want to take on the risk. So employers are not required to submit their written policies to OSHA unless they're requested. However, OSHA could request to see the employer's policies, and that policy will have to be given to them within 4 hours, 4 business hours. So there would be no time once it's requested to kind of scramble and get a policy in place. You have to have and take steps to have that to be able to give to them if there's some sort of complaint or random inspection, something like that. So you want to make sure you have those in place and ready to be given to a regulator if it's requested. So employers, you'll have to get and maintain records of their vaccination status, including a roster of employee vaccinations. If no proof of vaccination is actually given to you, then you must treat the employees as unvaccinated. Even if they were vaccinated, they just can't find it. And I'm going to talk about, you can request an attestation if they just truly cannot get the record of the vaccination, but that should be kind of a last resort. In other words, you want to make sure that they have some sort of proof, whether it's from the doctor, it's their vaccine card, whether it's some kind of medical record that they give to you to demonstrate vaccination status for whether or not they get both doses under the Moderna, the Pfizer, or the 1-dose J&J. And I think they actually just released the 2nd dose for that, not including boosters. And so it's just very important that you start that roster and that is in place by December 6th, not January 4th. So the ETS, it has immediate effect in the 29 states where federal OSHA has jurisdiction. So if you're not familiar with this, OSHA has federal jurisdiction over 29 states. They have chosen not to implement a state-approved OSHA plan. Now, there are several other states that have state plans. And so these are kind of approved by federal OSHA. They say we want to run our own OSHA program, depending on our state. And in some states, they have jurisdiction over over the governmental plans, state and local governmental plans, as well as private employers. And so depending on where the work site location is what applies. Now, what's interesting about this ETS is that even if there's a state plan in place, meaning the state has taken control of OSHA, then this ETS still requires that state plan adopt just as effective measures. So they have to basically implement policies under the ETS that are as good or better than the ETS, not worse. And so they could retract their state OSHA status. The federal OSHA could if they refuse to comply, and many states have already said that they're not complying. So this will be highly litigated, I'm sure, but it may march on, because from what we've seen so far, most federal courts have upheld vaccine mandates. So remains to be seen, again, with all of the litigation happening in the different state legislatures and what they're doing. Now, specifically in Virginia, because Millen Group is located in Virginia, many of you probably are in Virginia, or you have the majority of your employees in Virginia. Virginia specifically operates an OSHA-approved state plan. It covers most private sector employees and all state and local government workers. So if you are a state or local government and you're not sure whether this applies to you, because a lot of times you are exempt from things, in all likelihood, the OSHA state plan will apply to you. And it has to be just as effective as the federal version. So this is what likely will happen in a state that has a state plan. They're just going to have to adopt what the federal standard says. So it'll be kind of the same, or maybe even more stringent. So just be careful with that. We know we have a new governor that was just elected in the state of Virginia and made national news, of course. And Youngkin, he has said that he would remove vaccine mandates, ban them, but of course that remains to be seen when he actually takes office, if anything will happen with that. So in the interim, I would just prepare for this ETS to go into effect as on schedule. So here are the questions that we needed answers to, and now we have them. So I mentioned before that it applies to employers with 100 or more employees, this threshold, and we didn't know exactly how that would apply, but now we know exactly how this will apply. So this count should be done at the employer level, the firm level, the corporate company-wide level. So if you have multiple work sites, we're going to count all employees across all the company work sites. So in other words, if you are a single employer, but you have many different locations, many different divisions, then you're going to count all your employees together. So therefore, a single corporate entity with multiple locations, all employees at all locations are counted. For example, if a single corporation has 50 small locations with at least 100 total employees in its combined locations, that employer would be covered even if some of the locations have just a couple of employees and maybe by themselves aren't over 100. So again, it's company-wide. What point, where is kind of the line where you know if you have 100 employees, maybe your locations fluctuate, or maybe your company fluctuates in employees. So this is pretty easy to address. Actually, they made it easy. And just keep in mind that this ETS is really wide sweeping, and they're trying to pull in as many employers as possible to try to get as many people vaccinated as possible. That's the whole point of it. So it's based on the number of employees as of the effective date of the standard, which is November 5th. If the employee had 100 or more employees on the effective date, November 5th, and the ETS applies for the rest of the 6 months of the standard. So this standard can go for 6 months. They could extend it, but at some point they would have to make it a permanent standard. But for now, it's 6 months, so that's probably into May. So then if you're in, once you're in, you're in. If at any point during the standard, you go over 100 employees, then you are subject to the ETS. If you drop back down at some point, it doesn't matter. Once you're in, you're in. You had 100 employees at some point during the standard, you're in for the rest of the standard, even if you drop below 100 at some other point. Now, what if you have related entities? Let's say you have some sort of common ownership. Maybe you're part of a control group. It doesn't specifically say that the control group rules apply, meaning we have enough common ownership. Typically, we look at that with different tax laws, different healthcare laws, ACA reporting, and so forth. It doesn't specifically talk about related employers being defined as those under the control group rules, but it does say that 2 or more related entities may be regarded as a single employer for OSHA if they handle safety measures as one company, in which case the employees of all entities making up the integrated single group must be counted. So if you have to look at the safety practices. So this could be related to kind of your handbook. You have one handbook for kind of all of the different companies. You might look at payroll. This is where I would definitely get with employment law counsel to kind of determine, okay, are we actually related with regard to our safety measures or not so much? And so this is going to be kind of a legal determination, I would say, because it's not exactly clear. If you kind of think, yeah, we have multiple companies, maybe we have a management company and some holding companies, then the safe bet would be to just assume that all companies are related and that you have to follow the ETS. That would be kind of the most conservative viewpoint of this. But again, it just talks about it related to how safety measures are handled. Now, will employers be required to collect proof of the vaccination? Yes, absolutely. Employers must get proof and keep a roster of employees' vaccination status. So acceptable proof includes records from a healthcare provider, pharmacy like CVS or Walgreens, a COVID vaccine card, or some type of medical record documenting the vaccine. So if they can't find it or can't produce some sort of proof from a provider or a pharmacy, then the last resort is that you need to get a signed attestation saying that they've been vaccinated. There are multiple sample attestations out there. You need to check SHRM for sure. Most of you are probably members of SHRM. They have And I've linked them in the last slide below for some sample policies and procedures related to this ETS. They've updated them, as well as a sample vaccination attestation letter that you could have them sign. And it has to say basically that they believe it's truthful, that they could be, there could be some sort of enforcement taken on them if they lie about this. So it's got to be a pretty strict sort of binding attestation, in other words. So employers, once you have that proof, you have to keep a roster. There are also multiple tools that I've already seen that have been released to kind of help you track the vaccination status of employees. Vaccination includes the 2-dose vaccination for Pfizer or for Moderna, or the J&J, which is a 1-dose. It does not include boosters, at least for now. Maybe that could change, but that is fully vaccinated. I'm going to talk about what about if they've had COVID already and they're immune, they have natural immunity. I'll just say right now that it says in several, probably 5 pages of the ETS, that they've examined that and that they can't find, they don't have actual, I wouldn't say proof, but they can't determine if that's the same as being vaccinated. So essentially, if somebody's had COVID before, they don't consider that to be vaccinated, fully vaccinated for purposes of this ETS. So, and I see some questions coming in. I'm going to get to those questions. So thanks for your questions. So if you could hold your questions until we get through these portions, then I'm happy to answer any questions I didn't address. Okay, so we know that you have to collect the proof of the vaccination status and keep a roster, and especially have to keep a roster if it's requested by OSHA, one of the OSHA representatives. So who's going to have to pay for testing? So if you decide to implement a policy where you allow either vaccination or weekly testing and mask wearing, then who has to actually pay for the testing? So the ETS specifically says it does not require employers to pay for any costs associated with testing, but you can if you want to. However, employer payment for testing may be required by other laws, such as state law. Collective bargaining agreements could require that. So check again with your employment law counsel as it relates to perhaps state law and any mandatory testing payments or compensable. Is it compensable? OSHA expects that some workers will negotiate the terms of the payment. So some have said that you could perhaps include the cost of testing, like it should be paid back by the employee. Some have said that time to get tested could be compensable. And so it's not clear, though, in the standard whether or not it actually is. So until we have further guidance from OSHA or from some other governing body regarding maybe the FLSA, from Department of Labor, we don't really know if that's compensable, but I think the conservative approach would be to consider it compensable. So again, we want to just make sure that any state or local laws. Also, keep in mind that many of you might be thinking, well, my health plan covers testing. But in many cases, the health plans have decided not to cover surveillance testing for return to work policies, and will only cover testing related to an actual diagnosis. And so you'll need to check with your health plan carrier, which Millen Group can help you understand what type of testing is going to be covered under the health plan for your employees that are actually enrolled on the health plan. And so you may want to take steps to come up with some sort of testing policy if, again, you're going to allow employees to kind of take this other option to being vaccinated. Now, employers can just say, vaccinated or it's as a condition of employment. However, you do have to provide accommodations for religious accommodations and disability related accommodations. And so one of the accommodations could be, if they actually, it's not an undue hardship, could be to require, again, weekly testing for those who need an accommodation. And so again, you're going to need to determine how you're going to allow testing to take place. Will you compensate for it? Will you pay for it? Will they have to pay for it? And determine what kind of testing kind of you'll implement. I'm going to talk about that in just a minute, about the actual testing that's applicable, it's allowed, the kind of testing that they say is permissible. Now, will the ETS face legal challenges? Yes, and it already has, as we all know. There was a stay issued by the Fifth Circuit Court of Appeals last week. A stay is just kind of a hold on any enforcement from OSHA of this rule, but we could have a stay lifted at any point in time. It does, we think, apply nationwide because it was issued from a federal U.S. Court of Appeals, which typically doesn't just apply to that district. Certain states that are in that district, that usually will apply nationwide, and that's kind of the consensus. I've heard lawyers say that it only applies to the Fifth Circuit, but I think since we're a few days into this, I think it does apply on a nationwide basis. And so there are now, however, ETS lawsuits pending in almost all of the federal district courts. Some districts have multiple lawsuits within them. I think the Fifth Circuit has 5 or 6 just in that circuit, which is where Texas is. And so a lot of them are coming from there. So in this situation, according to the federal rules, what's supposed to happen now when we have so many lawsuits coming out of all the districts related to this one standard is they will combine all of them. They become essentially consolidated. And so in this situation, according to these federal rules, challenges will be consolidated and heard by a single U.S. District Court of Appeals. A special judicial panel will conduct kind of a lottery to figure out which one will take the case. And the lottery, again, is supposed to be chance, and it'll depend on who kind of wins the lottery. The court to hear the litigation will be drawn from a drum containing an entry from each circuit court wherein a constituent petition for review is pending. So that's what they actually said in their ruling. So what this means is that everybody kind of throws into the hat one challenge, and then they basically pick from a lottery which court is going to essentially rule on this case. Which going to take the consolidated challenges to kind of make it so that we don't have multiple cases going in different district courts. And so this is what is supposed to happen. We can expect that to happen, that lottery to happen November 16th, which might actually push back or delay enforcement of the OSHA ETS. But again, we don't know that for sure. And so again, I would proceed as usual with the timelines given to us right now. So what type of testing will be required? So under the ETS itself, a COVID-19 test that is cleared, approved, authorized, including for emergency use authorization by the FDA to detect current or infection of COVID-19 virus, including the OTC antigen test, is permissible. So that the self-administered tests that you can swab, you can purchase them at any grocery store or Walgreens or CVS, those are permissible. However, they cannot be self-taken and self-read. So the employee will have to either take it in front of you and you'll have to read the results, or it can be proctored by a telehealth proctor, whatever that actually is. So apparently there are proctors out there that can watch them take the test and confirm that it is a true result. So perhaps some employers are saying that they will have tests, those kind of over-the-counter tests at work. They can take the test there, you can read the result, and that could be something that you do weekly for each employee that either has an accommodation or you provide the alternative to vaccination status, which is weekly testing and mask wearing. So other types of tests, of course, are approved, such as the PCR test, which takes longer, but I could see that most employers would probably use the rapid test because we don't want to wait days for results where employees can't come back to work until they produce a positive test result. So this can get pretty hairy, pretty interesting really quickly. Again, we want to make sure our policies and procedures are reviewed by Employment Law Council before instituting these. Also, are remote employees covered? What if you have 100% remote workers, they never come into the work site? They would not be covered under the standard, meaning they don't have to be vaccinated or produce weekly tests because they never come on the work site. But if you do have remote workers that come in periodically, maybe they come in once a week, once a month, then they would either be required to tell you their vaccination status when they come into the workplace and probably beforehand, or if they refuse to provide that or are going to remain unvaccinated, then they would have to have a positive test and mask wearing before entering your work site. They are included also in the count for 100 employees. And I want to be clear on how you count the employees and go back to that for just a moment. So you would include remote workers, employees across the country. You would include part-time employees as one employee. You would include any temporary employees as long as you are considered their common law employer. You would also include any seasonal workers. So you basically include anybody that you're paying, who's on your payroll, and include them in the count. Again, the remote workers are not covered by the standard in the fact that they have to be vaccinated or wear a mask or be tested weekly, but if they do, they would need to be, that would need to happen before they enter the work site. But again, they need to be included in the count to know whether or not you're over 100 lives or not. So PTO for vaccination. So this is very, very clear in the ETS, and there are some wonderful FAQs that OSHA has released, which I have linked at the end of this presentation, that you really need to bookmark, take a look at. They're very well done, and they answer a lot of the questions that you likely have. So PTO for vaccination itself, you have to provide employees a reasonable time, paid time off, including up to 4 hours. And I say up to 4 hours. It doesn't have to always be 4 hours, but a reasonable time to actually get vaccinated if it's during the workday. It's not automatically 4 hours. In fact, in the ETS and in the FAQs, it talks about 55 minutes being reasonable for time to drive there, get the vaccine, and come back to work. So it's not automatically 4 hours, but it needs to be up to 4 hours. So you'll have to gauge that with your population. And that would be to receive each primary vaccination dose. You're not obligated to reimburse employees for transportation costs. It cannot be offset by any other leave that they have accrued. So paid sick leave, vacation time, PTO, it has to be in addition to that. It's very clear. Now, if they get vaccinated outside of the workday, or perhaps on a weekend or at night, then you don't have to compensate them. But if they go during the workday, then you have to essentially let them do that and provide that paid time off. Also, it says that they have to have this sick leave time to recover from the effects of the vaccine. So if they have side effects, which many of us did from certain doses, then you'll have to provide up to 2 days. There's a 2-day cap that says that recovery, 2 days recovery is a reasonable time frame. Again, we're not sure if testing itself would be compensable. It doesn't address that. So again, I would, in the essence of to encourage you to be more conservative, you could probably just say, yes, it is compensable. So what happens in states that ban mandates? So we have several states, every state adding by the day, I believe, such as Texas, Governor Abbott, Alabama just issued, they actually voted, the legislation voted on banning any kind of vaccine mandates that would be essentially, that would make vaccination status a condition of employment. And so we've seen several states either issue executive orders or their state legislatures have actually passed state legislation banning certain aspects of vaccination mandates. So essentially what it says in the ETS, and it goes on and on and on about this in both the FAQs and in the ETS itself, which is about 500 pages if you're interested in looking through it. It talks about how they believe that their OSHA federal mandate supersedes, preempts, in other words, any state law. And so this will have to be kind of reconciled in the courts, if at all. So I would say, and what most employment law attorneys are saying is that if you are subject to the federal ETS, meaning you are over 100 lives, if you are subject to the other ETS related to healthcare workers or federal contractors, which we're not going to have time to talk about today, then and you're in one of these states that has a sort of ban on it, maybe you're a small employer and you're in one of these states that has a ban on it, then most likely state law would apply at that point, because federal OSHA rules don't apply to you, or this rule doesn't apply to you. So but we have to walk a fine line with this, because they could, for example, make this applicable to smaller employers at some point. So for all intents and purposes, I think that if you are in a state that has a governor banning mandates or some sort of legislative adoption of some sort of ban on mandates, then just look at the state rules and see, does this apply to me, or am I brought in by the ETS itself? And in that case, probably the ETS will preempt any state law. But again, something to definitely consult with legal counsel about, because it's just not clear on that area of things. So some employer takeaways as it relates to the ETS, because I want to talk about incentives as well, because I think a lot of you are interested in incentives, more so than I thought at first. I talked to a lot of employers who are interested in incentives, which we'll get to in just a moment. But for now, with all of the litigation happening, with all of the information out there, I would still just go ahead and adopt procedures for determining employees' vaccination status. You should just go ahead and prepare to implement a system for asking employees whether they have been vaccinated, maintain those confidential records of their vaccination status, determine if you will permit weekly testing for unvaccinated employees, and also consider if you will put in an incentive for health plan premiums to further encourage people to become vaccinated. Also, you'll need to provide a policy PTO for individuals to become vaccinated if it's during the workday, and determine how you will implement the procedure for PTO to recover from the side effects. Again, that can be up to 2 days to recover from those side effects. Educate your employees on the new policy. This is actually a requirement. You have to educate them. You have to communicate to them what's happening. The new policy that's in place, communicate CDC information, and plan for, if you haven't already, again, accommodation requests for religious accommodations, which can be particularly tricky. And I have linked a specific SHRM article and policy related to this very issue. And also for disability accommodations, which can be a lot easier to identify because they have to produce a doctor's note, usually a provider's note. And so, determine, of course, employees' vaccination status by gathering the acceptable proof. Again, whether it's that attestation or requiring the vaccination card or something from the provider. Maintain a roster of those names and keep it around, because we may eventually have to have everybody have a booster shot. No telling how this is going to shake out. Review your policies with competent employment law counsel. It's worth the investment. So many of you maybe work with general counsel, but I would consult with somebody who's an expert in OSHA, as well as other employment law matters that can be impacted under this rule. It's very, very important, especially EEOC rules, accommodation requests, etc. So let me get to the questions, make sure that I've answered these. How do we know if we can trust the attestation? What if the employees that refuse vaccinations just fill out the forms? So this is an interesting question, and I think it does address this in the FAQs, that this has to be a last resort. And there are several sample policies and procedures that kind of list the severity of providing false information. So again, you want to try very hard to get an actual proof, document of proof of vaccination status. And then if they can't produce it, then the attestation needs to be very clear about any sort of consequences for providing false information. So termination of employment, something like that. So you can't hold their hands and know everything, but an attestation should be sufficient. In other words, if you were asked to provide the proof and you had a signed attestation and OSHA requested it, then you would be able to demonstrate that. But you need to be able to show that most employees, though, that you took steps to actually gather true records of vaccination status, whether the card or provider note or something like that. Can you please address whether time spent by the employee for weekly testing is considered compensable? If yes, does it have to be paid in the employee's regular rate of pay? So again, this is not clear, unfortunately, exactly how, whether or not that's compensable. But again, I would err on the side of caution that it likely is, and maybe take steps to maybe test in the workplace so that they're not taking, hours and hours to be tested, and it can just be done more easily. So again, good question for Employment Law Counsel, because we just don't know. So again, if you have any other questions related to the ETS, please type them into the chat box and I will have time hopefully at the end. But I want to address quickly, the issue of providing an incentive tied to the health plan premiums, because this is what many companies have done already. Delta Airlines did this, and so I want to talk about it because some of you might be interested in further incentivizing your employees to become vaccinated. So why would you even do this if you have to do it? And there's a lot of reasons that I could come up with. So the employer wants to foster goodwill, help further encourage vaccination, give them a further reason to become vaccinated rather than just kind of the carrot and the stick approach. Perhaps the ETS doesn't apply to your organization. Maybe you're too small, or perhaps you're in a state where you think this is banned. I don't know. That could be one reason. But really just being too small, not being a federal contractor, not receiving any reimbursements from Medicaid or Medicare regards to the healthcare ETS. And you just want to have some way to maybe incentivize people to become vaccinated that doesn't involve this being a condition of employment or having to test weekly. Maybe this is something you want to do instead. Also, making strides to impact your claim spend. If you are self-funded and you have a direct line of sight into how much your claims are costing, and you've had maybe a few employees who were in the hospital or ICU, or their spouses, their dependents were in the hospital because of COVID, you want to really encourage them to become vaccinated because it has such a large impact on your claim spend. Again, especially if you are self-funded and that has a direct impact on the types of claims that you're paying for, then yeah, this is going to be something you want to take a look at. I've spoken to many employers that are more kind of what I would call paternal in nature and want to just foster that goodwill, want to provide this incentive, want to, further encourage employees with the carrot approach. This is going to be something you want to pay attention to if that's you. So first of all, for any premium incentives, we have to consider the wellness program rules. So whenever we talk about a premium differential for some sort of wellness activity, then we're going to implicate rules under the EEOC and also under HIPAA. And so I want to talk mainly today about HIPAA because Delta Airlines, what they did a couple of months ago does, in fact, totally implicate HIPAA, the wellness program rules under HIPAA, and all of the hoops that you have to jump through if you have a wellness program that's tied to a vaccination. And so, first of all, looking at the EEOC guidance, really this is important because we want to know, does the EEOC allow us to ask about vaccination status? And if so, can we further incent people? And they basically said, yes, that's fine, as long as that it's not so coercive that it can be considered involuntary at that point, meaning the amount isn't so high that we are basically punishing people by providing an incentive or surcharge that's so high that can't any longer be considered voluntary. So we want to be careful with that. Again, providing incentives or surcharges related to the health plan. They did say that if the employer actually administers the vaccine, and that may happen with an employer that's a hospital, a clinic, a provider's office, you have the vaccine there, then in that case, you have to be very careful with incentives. They can only be very minuscule, it doesn't say what exactly that is, but it does say that it can't be so coercive as to be considered involuntary at that point. Then the incentive itself could be very minimal, like a gift card, a $5 or $10 gift card to Starbucks, or maybe t-shirt or something like that, just very, very insignificant. However, if the vaccination is administered by somebody in the community, like CVS, Walgreens, Walmart, the doctor, clinic, whatever, at the airport, I saw the National Guard issuing vaccinations in the airport. If it's out in the community, then the incentive has no limit under the EEOC's rules. However, it does under the HIPAA rules, which are actually more important than the EEOC's rules at this point. Also, under the EEOC's rules, they do specifically say that anything that's tied to vaccination status would be considered confidential medical information under the ADA, and that it should be stored separately from personnel files. So that's how they view any kind of medical records that you will be getting from employees themselves. And I'm going to talk about whether or not it's HIPAA PHI in just a moment, because I know that you might be wondering, does this violate HIPAA? And it actually depends. So again, we have HIPAA wellness program rules, which are different, separate, and apart from the EEOC's rules that I just mentioned. And these are the ones that Delta Airlines likely implicated when they came out with their surcharge a few months ago. So the premium surcharge for vaccination has been confirmed with the Department of Labor and CMS to be an activity-only health contingent wellness program under the HIPAA rules. That was released back in October. And you might be saying, what does that mean? It just means that, yes, these hoops that you have to jump through apply to an organization that wants to implement some sort of surcharge or incentive, however you're doing it, related to health plan premiums themselves. Again, it's pulled in because of the group health plan. When you pull in a group health plan, when you attach it to the group health plan, that's when HIPAA rules apply. Within these rules, there are 5 different requirements that have to be met in order to meet the HIPAA rules. The most kind of difficult one to meet is the reasonable alternative standard. And so I'm going to talk about that in just a moment. And then how much can the actual incentive or surcharge be when you are required to comply with the HIPAA wellness program rules? So there are also some other rules that apply when these rules are coming into place. They have to be reasonably designed to promote health or prevent disease. That one's a pretty easy bar to clear. They have to have the opportunity to qualify for the reward at least once per year. The total reward or incentive or surcharge cannot exceed 30% of the total cost of coverage. So think about the amount of coverage, the invoiced amount that's on your bill, the COBRA amount. If you're self-funded, it can't be 30% of that, can't exceed that amount. And you must provide some other way, we call it a reasonable alternative standard, to be able to meet the requirement to get the surcharge taken off or to receive the incentive, the same as vaccinated employees receive. And you have to also have a notice of a reasonable alternative standard in your open enrollment packets or mid-year if you're doing it outside of your normal open enrollment timeframe. And so what exactly would be a possible reasonable alternative standard? Another way to get the reward rather than being fully vaccinated. That could be possibly mask wearing. Again, this is kind of in line with the mandate itself. So you could kind of, mimic that, whether employees are vaccinated. If they aren't vaccinated or cannot be vaccinated because they have like a doctor's note not to be vaccinated, then you would need to provide them with an alternative standard, which could be attesting to the fact that they will wear a mask or they will engage in weekly testing, although weekly testing for this purpose might be too stringent, might be overly burdensome to receive the actual reward or remove the surcharge. They also you may have to provide a waiver of standard if they can't meet the standard or the reasonable alternative standard. So again, you might have to waive it altogether and give them the fully vaccinated rate, in other words. So when the standard is met, you have to refund the entire premium surcharge or premium incentive back to the start of the coverage period. So this is very important with this type of wellness program, or if you have a tobacco surcharge, you have to refund it back to the start of the plan year. You can't just prospectively start to apply it once they meet the standard. It's back to the start of the plan year. Very, very important. And again, there's a notice required under HIPAA of reasonable alternative standards that you have to give out before you're going to start applying this rule to them. An example, and this ties back to Delta Airlines. They issued in their press release that they were going to apply $200 per month surcharge for employees that remained unvaccinated. It's not clear to me whether they actually provided a reasonable alternative standard, meaning for those employees who objected to that, did they provide another way to get that surcharge taken off of their health plan premiums? I don't think they did. It's not clear. Maybe they have by now, but it wasn't made apparent in their press release back, I think, in August. And so don't be Delta Airlines. You want to make sure to follow the rules. They have a lot of money and a lot of lawyers, and maybe they didn't know about that or they didn't care. Not clear, but they were clearly in violation of the HIPAA wellness program rules, and they could be fined for it and may have to pay restitution if the Department of Labor has something to say about it. So I just want to provide an example of a limit or a surcharge or an incentive that's too high. And I believe that depending on how much Delta Airlines employee-only coverage amount is, again, it's the full amount, employee plus employer contribution, how much that actually went over that amount. So I've put in this example here, $350, which is $4,200 per year of an employees-only health plan premium. And the cost, the plan offered employees a health contingent wellness program, which consists of a vaccination surcharge for those who remain unvaccinated or complete the reasonable alternative standard. The surcharge is an annual premium surcharge of $200 per month, which is $2,400 per year. Since $2,400 is clearly more than 30% of the total cost of coverage in this instance, in this example, then it's too high, it exceeds the HIPAA limit. Now, looking at one that's not too high, let's say we use those same numbers, but the premium rebate is $25 per month instead of $200 per month. So since that's $300 a year, that's clearly much lower than 30% of the total employee-only cost of coverage. So this one would be compliant under the HIPAA wellness program rules. Also, if you're going to implement any surcharge, it impacts affordability. So all of you, probably a lot of you, are applicable large employers. You have to comply with the employer mandate. You have to do your 1095C and 1094C reporting each year to the IRS. And so if that's you, then if you implement a surcharge, you have to use the unvaccinated rate in determining affordability. And so I put an example here of how this will work. So an employer imposes a surcharge where employees who are vaccinated pay $100 per month for self-only coverage, which is affordable using the federal poverty level safe harbor. So a lot of you probably can use the safe harbor if your lowest cost employee only rate is under $103 per month, I think it is. So if you're only charging $20 a month, even if the employee is enrolled in some higher level plan, then you can use federal poverty level affordability for your reporting and to hopefully prevent you from getting a penalty letter. In this situation, employees who are not vaccinated are charged $150 for self-only coverage. So in this instance, the employer must report the cost of the plan to employees as $150, not $100, on all the employees' Forms 1095C, which could significantly impact the affordability of the plan and for its employees. You really have to watch that if you're going to implement a surcharge or an incentive, because it does impact your affordability testing. So I put that here where you can see on line 15, this is a 1095C, very popular form that we have to look at each year. So you can see here that in the example that I just provided, this line here would be 150, which means you can't use federal poverty level anymore. You have to use some other safe harbor. If employees are not offered affordable coverage and they get a premium tax credit on the exchange, then you could wind up getting a penalty from the IRS. So just watch that. Make sure that you're understanding that and calculating that. I've worked with many employers that are looking at that and making sure that their coverage is still affordable. Privacy and confidentiality considerations. So consider your local state data privacy laws. Almost every state has data privacy laws related to employers and what you have to do with protected information, private information. Don't ask for information related to the family members. Just keep it to the employees. require the employee, not the provider, not their doctor, to transmit vaccine information to you. So they can bring you information from their provider, but don't have the provider send it to you directly, because then you could be considered a group health plan then, and that is when it becomes protected information under HIPAA. So if the employee just gives it to you, their vaccine card, that's not PHI under HIPAA. It's when it comes from the group health plan or from the provider directly, where it could become PHI, and therefore all of the HIPAA rules apply as protected health information. The EEOC considers vaccination information identifiable information that's subject to the ADA confidentiality rules, which means that it has to be just kept separately from the personnel file. It is considered private information, so you have to make sure it's confidential and not just given out to employees. We don't want to release a roster to everybody in the company. Only minimum necessary standards would apply there.
Join the meeting.
And so just be careful with this information, but just know that it's not considered PHI under HIPAA unless you're getting information directly from the health plan with regard to testing status, vaccination status, which likely isn't going to happen. So just be careful with that. Now, if you do implement a incentive or surcharge, then you will need to treat it as PHI, because then you pulled in the group health plan by charging an incentive or surcharge to the health plan itself. So what to do, some takeaways again: consider whether you will provide an incentive or impose a surcharge, and if so, whether or not these rules are implicated. Identify a reasonable alternative standard, another way to get the reward, and ensure that that reward doesn't exceed these thresholds. Consider how it will impact affordability. If you are an applicable large employer that's subject to the employer mandate, you have to do ACA reporting. Manage your privacy risks, and mid-year plan changes would likely open up a qualifying life event for employees to be able to make changes to their elections. So keep this in mind, though. If you're going to implement these changes in the middle of your plan year, this is what can happen. You might have to amend your SPD, your WRAP SPD, or and provide a summary of material modifications. And of course, we just recommend contacting competent employment law counsel to review these types of policies, as well as policies related to the ETS. And so I provided several really, really great resources here that I would encourage you to take a look at, especially the FAQs, where I put read this. These are extremely helpful. Go ahead and bookmark them. There's probably 100 FAQs related to the OSHA ETS and common employer questions that you likely have. I've included SHRM sample policies and procedures, article on religious accommodations, as well as religious objections to vaccine mandates. So this will answer a lot of your questions with regard to religious accommodations, because I know this is a particularly contentious area. And so we have just a few moments for any questions. Are there any, if you have any questions, please type them into the chat, and we'll take just a few moments to answer your final questions before we end today's call. So if under, make sure I don't miss any here. If under 100 employees, are there any requirements with mandates? So if you have truly under 100 employees, unless your state, makes the ETS more strict or imposes further requirements, and you're under a state plan, at least under OSHA's jurisdiction, then there doesn't appear to be any mandates that require vaccination status as a contingent for employment. And so you'll need to check with your state specifically, but in all likelihood, no. If you're under, or you're not up, you don't apply to, or you're not subject to the ETS itself, then you would not have to comply with this. But at some point you may have to, because they may further extend this down to smaller employers at some point. Should we get a signed statement from employees who are not vaccinated to confirm this? So again, if you cannot, or they cannot produce any sort of vaccine proof of one of the types of proof that are allowed, then you should receive and you should get a signed attestation as a last resort. And that's what you have. It is what it is. That's what you have. You could demonstrate that they gave it to you, at least that you took steps to comply with this rule, again, as a last resort. To ensure I understand, the vaccine status becomes PHI if the employee has their HC provider send it over. Likely, yes. If the provider sends it to you directly, then that could be considered a group health plan in and of itself. So we want to kind of just have the employee give it to you from their provider, not directly from the provider, and certainly not pulling claims information to determine vaccination status. That is where, in other words, it's not wrong. It's just considered PHI at that point. You have to have policies and procedures. You have to encrypt your emails. You have to have firewalls set up. It's just a very onerous requirement. Once something is considered PHI, you're basically like a clinic or a hospital at that point. So be very careful with how you get the information from the employees. If it's just given to you by the employees, you just then have to treat it as confidential information and manage it in a confidential manner. Do you have any resources where I can check my state's specific requirements? I'm in Maryland. So I think that one of the things that I've attached here in the resources page that you see on the screen is the OSHA state plans here. You'll want to check to see if your state has a state plan, and if so, they have to adopt any just as effective measures within 30 days, and that started on the 5th of November. So we want to check to see if you have a state plan, and I would just look at perhaps SHRM and see if there's any state-specific requirements with regard to Maryland. Because of HIPAA laws, we are not able to tell the supervisors who needs to wear a mask. How do we make sure unvaccinated employees are complying with this mandate if only 2 HR employees who know this confidential information and we have 200 employees? So this, I think what you're asking is that you're not able to, we'll have to research this question, because this gets into who you can identify people who aren't wearing a mask and who are, and so we'll get the answer for you. Is it the same for test results if healthcare provider sends the test? Yeah, so don't let the provider send you the result. Again, have the employee give you the test result. Again, it has to be from a provider or proctored for telehealth, or you can witness the testing itself. So I think we're over time, so we'll go ahead and wrap it up. I'm going to give it back over to John. Thanks so much for your time today. Hopefully this was helpful for you all. So thanks again.
Sarah, great job. In fact, the first comment that came in, Sarah is doing a stellar job covering many facets, no questions. This is from Robin. Thanks, Robin. I do have a bunch of more questions that came in. What I'm going to do is I'll get a record of all these. And if you guys want, I will send out a recap of some of these. And if you have more specific detailed information and you need some support, reach out to us. We can coordinate a call, or you can call Sarah directly, but you can work that through us. One thing I want to just mention is that this is a very complicated puzzle, this whole topic, right? And so the other advisor that I would suggest you get in the mix of this is your healthcare consultant broker, because we have different perspectives about what other employers are doing when it comes to incentives or surcharges. We understand the ACA affordability. If you need some support on that, the rates, the percentages have changed on what you can charge. And so just keep in mind that a lot of employers are struggling with attracting and retaining talent. So don't make this decision of a surcharge or an incentive in a vacuum, because you want to make sure you have a well-rounded thought approach about this whole thing. So with that being said, Sarah, thank you so much. And if you guys have any questions, you can go to our website. You can email me directly. And hope you guys have a great weekend. And thanks again, Sarah.